remarkable in his talent in being able to use a theory of a case to resolve cases. And I've had personal experience both as a litigator and, I may add, as a party, in which Mr. Gasee's ability in that regard has been quite spectacular. I understand the lights are being dimmed just a touch. I think that's all right. It's an abrupt dimming, but it'll work. And perhaps I could ask Mr. Gasee if he could come forward and enlighten us. Thank you.
Funny you should say that I'm going to enlighten you when you turn the lights off. There goes the theory of my case. Hello. Good morning, ladies and gentlemen. Just before we get into the formal part of my presentation, I'm going to just want to point out that just like the theory of your case, the theory of a speech, you can never start too soon to get your theory forward. And that's why I had to put this cartoon up here. Just, I don't know if you can see it at the back. It says, I asked you, would I be doing this if I didn't really have an airtight case? And the cartoon character is thumbing his nose at the jury. And so I wanted you to get the theory of my speech or seminar delivery to you right from the start. I'm going to try and make it a little practical, a little bit entertaining, and that's what, but I wanted to get that message here right from the start. That's my theme. And similar in the theme of a case, you want to present it as soon as possible, get the judge's attention, get the jury's attention, so they know right from the start what your philosophy is. Now, I just, perhaps after listening to some of the speakers, I find it interesting that we're all talking, and none of us heard the other person's presentations before. You'll see there's a common theme going through all the deliveries. Consistency in your theme, hammering home the theme, making it logical and practical. So bear in mind, after you sit back and at the end of the day and hear all the speakers or read all the papers, pick up the consistency of what everyone's saying, and if every 5 or 6 people say it, then may suggest strongly that you want to use it. Just to give you some example of some of the theories or tactics I've had, you just looking back, I remember I had a case involving to report a case over a tree dispute. And the trees down the center of our, two neighbors had trees down the middle of their property. And I thought it would be interesting to bring a big branch into the courtroom to just demonstrate the issue. I brought a great big branch into the courtroom, and I was fortunate enough to have Mr. Justice Hollingworth as the trial judge. And he walked in, and he said, and he was known for his sense of humor. He said, Mr. Gasee, what branch of the law is this? And as soon as he said that, I said, I got you. He was paying attention, he was humorous, he wanted to have some fun with me. So I responded, Your Honor, this is an important case, I want you to go out on a limb. And after that, for the rest of the 2 weeks, we had a lot of fun together, making tree jokes, but the important part, he was paying attention, and he knew the theory of my case right away. It was about a tree and a tree dispute and difficult things. So he did go out on a limb at the end of the case, and it was an interesting branch of law. But we always remember that, so we got his attention. The theory of the case came through right from the start. By way of another example, I just noticed that some colleagues here in the courtroom have had cases with it. And that's the best way to give you some examples of theories and maybe talk about some practical cases. Brian Leck is here from the TTC. He was involved in the TTC crash, and I had an unfortunate client. And my theory of the case was that the client was on the subway crash, and he was injured. And that was my theory of the case, that he was a tragic victim of this tragic subway crash. Except Brian destroyed my theory by showing that my client may not have been on the subway train at all, and it was a sham. But that was an example of conflicting theories. But I had a theory. Okay? Similarly, I had another case with Brian, unfortunately, or fortunately for him, where I had a person who was in a car accident, and she was allegedly badly injured, and her major problem didn't have physical injury, she had psychiatric injuries. And the theory of my case is that my client was nuts arising from this accident, and she had psychiatric problems, and I thought it would take a week or two for the case, and we showed that she had psychiatric problems, but that was the theory of my case. Unfortunately, at the end of the case, the court found, or the jury found, that my client was perfectly sane and had no psychiatric problems. It turned out that I was the one who had psychiatric problems for taking the case. And there was somebody nuts in the case, that it was me. And there should have been a hint during that case, because Brian made me a very reasonable offer of settlement, which my client rejected. And I thought, for the sake of the client, I'd insist on a large retainer as a good tack. Not that I wanted the large retainer, but I said, give me $40,000 if you want to go ahead with this case. Feeling that no way in the world would she give me that retainer. And unfortunately, she gave me the retainer. So I said to myself, that proves that she's not that she gave me the retainer. It's consistent with my case. Unfortunately, the jury didn't agree. And so those are just some examples of theories of cases that didn't work. I have another, Rob Bajoni is here also, another colleague of ours who I had a case with recently. This is half over, so to speak. And right from the start of the case, my first letter to him, I wrote a letter underlining my theory of the case. And I underlined it. I actually underlined it in the letter. And Rob, being the gentleman is, wrote back and said, Bernie, I understand the theory of your case, but you don't have to underline it. I understand it. So the case went on for another 3 years, and for the next 3 years, every time I wrote him a letter, I put the theory of my case, and I underlined it. As a matter of fact, I double underlined it, because I knew it used to annoy him. So just to have fun, in case he sent a letter to his client, I always sent him the theory of my case right in the top, double underlined. So again, I'm not sure if these things work, but it was a way of delivering him a message to him and his client with the theory of the case and underline it. And so you want to get your theory up front. For example, Mr. Solomon mentioned about Goldilocks and the three bears, and that would be an interesting situation. Now, of course, we all know how sad Goldilocks is, a little girl lost in the woods. But if you're acting for the three bears, I would start off my theory right from the start saying Goldilocks is a burglar and a trespasser. Because you want to get away from this. She's a cute little girl lost in the woods. If you're representing the client, you represent the Goldilocks broke into the house. She's a burglar and a trespasser, and right from the start, you set your theory of your case. So again, that's his comment on some of the other people's comments. Also, Mel pointed it out quite properly that I've had many promissory notes, and he has many promissory note case, and we say, what kind of theory is there in a promissory note? How do you drive it home? Well, what I sometimes do, because I want to drive home that the promissory note is the document, and somebody's going to say I didn't have any independent advice, I don't read English, I often blow up and have an enlargement of the promissory note. I stick it right in front of the judge, an enlargement of the promissory note, so the judge can't miss that promissory note. Every time, after he hears all the arguments, no independent legal advice, didn't understand the English, couldn't read English, didn't understand how to sign a promissory note, no matter what, he always has this great big copy of the promissory note in front of him, because that's the theory of the case that doesn't go away. So if you just drive it home, a great big copy of the promissory note right in the front of your document book, and when you're summarizing up, the promissory note is blatantly in front of them. So it's another example of driving home your theory by emphasizing the document. Now to the formal presentation. Now, as everyone said, to some extent, there's a difference between theory and tactics, but to some extent, they overlap. And there's countless theories and countless tactics. And if you to present your case properly, you have to get the right tactic and the right theories for the right situation. And that's part of the fun and the challenge of being a lawyer. You can't just pick a tactic. Somebody said today, a promissory note, if it's a car accident case, you have to pick the right tactic for the right situation and plug it in. And that's part of your challenge. And you have to make sure that it's consistent and logical. For example, if one of the theories of your case is that your client's case is urgent, they have to get this property right away, or they have to get this relief right away, then you want to be consistent with that theory right from the start. And if you're seen bringing motions after motions after motions for particulars or for some innocuous thing that may not be important, it may be detracting from the theory of your case, because if it's that important, you should be wanting to get on to trial and push the case along, not be bogged down with motions or side issues. So again, it's important to be consistent with your case and that the theory be consistent. Now, right from the start, I think one of the key things, as soon as you know you're going to be involved in some dispute, I think one of the most important things, one of the opposing theories, is to make your guy the good guy. Look at the old cowboy movies. You want your guy to wear the white hat and be the good guy. You want the other side to wear the black hat and be the bad guy. And I find that the best way to do that is, where possible, to make my client the plaintiff. Because psychologically, everybody knows, or most people know, that the plaintiff is the person who's being abused, who should be outraged, and who's bringing a lawsuit. So where possible, if I know that a lawsuit is going to ensue, I try to sue first to be the plaintiff. I just had a situation where two clients were arguing, and they both said, well, okay, we're going to go to the lawyers and we're going to litigate this. And as soon as my client came to me, I said to myself, the other side is in the United States. So I want to be the plaintiff, rightly or wrongly, in my opinion, and I want the case to be up here in Canada. A, I don't want to lose the case, and B, it's to my client's advantage because he's in Canada. So A, I wanted to be the plaintiff because we wanted to be the good guy, seen to be clean and righteous, and as soon as you get the theory of my case, I want to move it along as soon as possible. It's consistent with the theory of my case that I want to get it to court as soon as possible. Now, certain advantages of being the plaintiff are, and these are tactical things, but it's part of the theory of your case. If you're the plaintiff, you have lots of advantages. You get to choose what court. Are you going to be in Ontario? Are you going to be in Toronto? Are you going to be Thunder Bay? So you get to choose where the case starts, where the trial prima facie is going to be, and what jurisdiction is it going to be in Dakota, Wisconsin, or Ontario. I would prefer Ontario since I practice here. So you get to choose where the case is going to be. Also, you get to choose the forum. Is it going to be a small claims court, the federal court, the superior court? So that's another advantage. And then you get to choose other tactics. Case management. Do you want the case to move along as part of your theory? Do you want the case to be complex track, fast track, slow track? You get to choose the track. So all these tactical advantages are part of the theory of your case that present an image of the case. If your case is urgent, you want to present that urgent to the judge, and you don't want to pick regular track case management because it gives the judge the impression that it's not in that hurry. So once you have your theory, everything you do thereafter has to plug in to your theory. The judge might say, that's a very minor point, why aren't you picking fast track if this is an urgent case? Similarly, if you're dealing with someone from a foreign jurisdiction or even another province, another part of Ontario, by picking your local court, you get the local advantage. I know if I have a case even in another part of Ontario, I worry half the time, how am I going to find the courthouse in Thunder Bay or Kapuskasing? Half the time I'm worried about how am I going to find the courthouse there. Whereas the other lawyer who has the local court knows where it is. So I feel I have an advantage if I'm in Toronto and the other lawyer has come to Toronto to my jurisdiction. I'd rather have in the lawsuit than playing with my ball in my ballpark. So again, being the plaintiff and picking the circumstances of the trial, it should be part of the general theory of your case. Similarly, by picking the case and starting the lawsuit, the timing of the lawsuit, you pick it to your convenience. If the other side is a seasonal business, if they're fishermen, you may want to bring the lawsuit in the fishing season when they're busy. If there's a strike going on and the other side are involved in a labor strike, or God forbid a TTC strike, or a subway thing, you may want to sue the TTC at an inopportune time because they're in the middle of a subway crash investigation or a strike and they haven't got time to deal with your lawsuit, so they're more likely to settle. So timing may be an example of your theory also. Pick a time that's convenient for you and inopportune for the other side. If you know the other side is going through a partnership dispute or a strike, for example, or the availability of witnesses. I just had an interesting situation where, as part of the theory of the case, it was an unfortunate case that we're involved with a student insurance company. It was a credibility issue, and it was going to be what the insurance agent said against what the person said. Unfortunately, the insurance agent who was going to testify against us was in a coma for the rest of his life. So that was an unfortunate thing, but from the point of view of my client, we knew from a tactical point of view that there's no way they could have anyone to testify because there was only two witnesses, the agent who was in a coma and my client. So we were pushing the case ahead, and even though the insurance company kept bluffing, there's no way you can do that, there's no way you can do it, we eventually settled on our terms because from a tactical point of view, we knew that our best place was in court, pushing ahead for a settlement and timing because we knew that the other witness could never show up. The second, so timing and picking the right forum and being the plaintiff, I'll call all that the first topic, which is commencing the lawsuit. The second area is what image do you want to portray of your client? And this is part of your whole presentation. If you're acting for a bank or insurance company or financial institution, you cannot portray your client as some poor, suffering, abused party. And you have to bear that in mind. If you're acting for a large institution, you may want to depict them or try and depict them, if the situation's right, as somebody who's looking for justice and fairness and trying to set a proper moral example, a high standard. On the other hand, if you're acting for an 80-year-old widow, you may want to call her throughout the trial Widow Jones. Or you're acting for a pensioner, you may want to call the person their Pensioner Smith. Or if you're acting for a wounded soldier, Sergeant Jones. In other words, you want to emphasize the strength of your case and look at your party or your client to see how they can fit into your theory. So if your client is someone who fits your theory, for example, an elderly lady, she may not understand the terms of the contract that the salesman took her. On the other hand, I had a case recently where I was suing a person who was trying to defend a loan, and they said they didn't understand the loan, except that person was an English professor at a university. So their theory wasn't very good. What she said, she didn't understand and didn't read the loan documents, and she didn't know what a promissory note and didn't bother to read it. Again, that other side's theory I submit was very weak because it wasn't consistent with logical. So you want to look who your clients are and where they fit in. Do they speak English? Are they immigrants? Do they understand our system? If not, maybe you have a chance to plead non est factum. They didn't understand, they were abused, as opposed to being a sophisticated client. So in picking your theory and in choosing the theory, you have to make sure that it's logical and consistent with your client. As if your client can put it off, not pull it off, because that sounds like you're conning somebody, but can your client present that theory consistently and logically? So you have to look at your client. Is your client a type of person who is shy? Can they testify? Or are they an aggressive person? Is your client, if your client gives an image of being a super salesman, a car salesman, a fast talker, is it likely that your client was conned as opposed to the old lady or the pensioner? So once you get your theory, you press on with your case. And I find another interesting, and I'm trying to give some practical thoughts that I enjoy about presenting the theory, is I use the concept of interest. Because interest nowadays is a very important concept, because unfortunately trials don't get an end sometime for 2-3 years. And I always think it's important to emphasize to the other side that interest is running and you're not going to forget about it. Because if you know you can collect from the other side, if you're suing a bank or an insurance company and you're trying to throw a light on the subject, so to speak, then you know that at the end of the day, not only if you're successful, you want to let them know you're going to demand every drop of interest. And one of the things that I suggest is, for example, if you're suing a credit card company and they have in their credit card terms, or you're suing a manufacturer and they have in their terms of contract, we give you credit at 24% or 18%, or we're selling you the goods at 18% or 24% interest. Then when you're suing them or countersuing them, counterclaim at 24% or 18%. Nothing makes them more nauseous or revulsive than to say that you're using their own interest rate against them. The credit card company is going to pay 24%. And you say, well, that's the rate in the agreement. We have an agreement that any outstanding debt is 24%. So if you're suing a manufacturer for damages because the products are no good, you can say the interest rate that we agreed between us is 24%. Or if the credit card company didn't honor your credit card at the right time, you're suing it for damages, 24%. That's what the contract plays. And that'll get their attention very, very quickly. It's always interesting that although they put in their contract 24% or 18%, when you suggest that they have to pay it, it seems to be a different story. Similarly, as Mel said, I find another interesting tool to the theory of your case is advertising. As he said in the Don Cherry advertising will save you a ton of money. And I made some examples that I want to go over with you, where as soon as you see the other side, I always look to their advertising. If it's a big company, what is their advertising? I just made some notes. I know there's a bank now that has a slogan, we're here to make it easier. Now, if that particular bank is a large public is suing you, you may want to say, is this lawsuit making it easier for my client? Is that a breach of warranty? You know, what about, you may owe money on the contract or the promise note, but maybe there's a collateral contract that you can countersue on because they are not making it easier for your client. You're countersuing on the collateral warranty, a breach of warranty, they're not making it easier. Or there's another case that I just had recently where the policy or the theme of the other side was satisfaction. And the whole company was draped in this satisfaction. They had a satisfaction department, they had a satisfaction officer, they had a satisfaction all over their showroom. And I was unsatisfied. And I actually went just before the trial to their showroom and asked for a copy of the great big banner right across their showroom that said satisfied. And I subpoenaed it. And my position was that we weren't satisfied and that they owed a warranty of satisfaction. And as a matter of fact, I got lucky and I subpoenaed their manuals, and they had a whole manual on satisfaction showing how they want to try and satisfy the client. Meanwhile, in this particular case, they had done nothing, absolutely nothing, to satisfy my client. So I'm saying that if you look at the advertising, sometimes you can either make the other side uneasy or uncomfortable or push it home. And in all my correspondence in that particular case, I wrote, unsatisfied customer writing to the satisfaction department. That was the theory of my case. Again, you never know how much it works, but at least it gives you some, quote, satisfaction in trying. I just made a list of some, and I want you to jot down. I left on my paper. I want you to think of some of the clients who you're suing, or it can work against you. Some of the clients you act for. And think of some of the theories of the thing. And it's like play this with your imagination. There's obviously, you'll recognize some of these things. There's a company that says, just do it. You probably know that is the clothing company. A builder, we build it better. Well, let's say you're suing a company and all their logos and all their stationery, they have we build it better. Doesn't that help your theory if they didn't do a good case in your particular case? A food chain has the theory, the things we should be, the way things should be. Another builder has the expression quality people in all their letterhead and all their advertising. Now, if you be misrepresented by their salesman, or their contractor, they haven't done a good job, and there's a serious credibility issue, you may want to remind them and emphasize the fact that although they're represented to be quality people, they may not. And you may even want to ask them on discovery, and I've done this, well, you advertise that you're quality people. What research did you do to get that slogan? How do you know that that's true? Have you done any research? Have you investigated? It reminds me of another situation where I was suing somebody, and all their packaging, they had the usual slogans: best, fastest, superior. And so I said, well, let's go through your packaging. What have you done to show you're the best? We don't have got a clue. We just put it down there. Well, what have you done to show that you're superior? I don't know. We haven't done any research. What have you done to show that you're the fastest? So I went through the whole packaging, and it was all just words put down, but nothing had been done to show that they justified the words on the packaging. So part of the theory of my case was that these people aren't very credible. If on their own packaging, the most important thing they lay out to the people, they have done no research, there's no basis to it, it's just, pardon expression, garbage that they put up for the sale, then maybe the rest of their case is garbage. Because the president doesn't know why they put all this in the packaging, then maybe he doesn't know anything about the particular case. So again, these are just examples. I'll give you some other ones where if there's a certain building company that has the expression, help is close to home. Now, if they're suing you, you don't feel very helpful from that company. The lowest price is the law. You'll probably recognize that one. And here's another one from an investment company has an expression, taking your money in a new direction. Now, God forbid you should invest with that company and lose money. You may want to look at their slogan and ask if that's what they mean by taking your money in a new direction. Here's one. Who's better? Nobody. I'm sure you know that one. Now, the question is, God forbid, or if you're lucky enough, maybe, depending on your point of view, to have a lawsuit against that particular company, and they're alleging who's better? Nobody. And you didn't get a good appliance from them, you didn't get service from them, or whatever the situation of your lawsuit, you may want to remind them that they're prominently advertising on the radio every day and in their newspaper that they're the best. And if they didn't give you the best, then you may be entitled to damages or compensation. It certainly make them uncomfortable that they don't want to go to court. I mean, your little dinky case show that they're not the best. And they may have to change their advertising because of your little case, because if they're not the best, or they're not better. So you may want to find out, if you happen to have a lawsuit against that company, why they're the better or why they're the best. Or there's another one, we deal excitement. That's one of the casinos. Let's say you go there and lose money. Is that exciting? Did they deal you excitement? Are you entitled to your money back? Is that a breach of warranty? Another one, your bank, your way. It may not be your way. You may not want to pay the bet back for 3 or 4 years. So again, I'm just using these as some extreme examples that you may be able to use the advertising and promotion against the people, against them. That's another case. One of the 2 or 3 final examples, and I won't get off this topic. another case with a manufacturing company. Their whole slogan was, "We're the fabricators. We're the fabricators." And at the end of my case, my closing line, it was a credibility case, and they weren't, in my opinion, very credible. I said to the judge, "Your Honor, I don't have to tell you here who are the fabricators." So again, it just fit up very well. And lastly, by way of example, and again, these can make the case subtle pressure as part of your theory. This is the theory against the other side as opposed to your theory. But it works this way. I had 2 cases recently against games companies. One was a manufacturer of a board game, and they didn't want to pay. I acted for the client who made the board game, and the people who ordered and designed it didn't want to pay. And we went to court, and there were several motions, and every time we kept on saying, "Your Honor, they're playing games, they're playing games, they're playing games." And that theory went through very judge, because even the judge would pick it up and say, "I think you're playing games, I agree you're playing games." And it worked very well. And we had 2 cases by what a coincidence against 2 games companies. We'd be able to use that coincidence. So this is this example of trying to use advertising against the other side, because there may be a warranty there, or it certainly make them uncomfortable as part of your theory. Now again, that can work against you. If you have to look at your client, if you have a client who has a theory, they want to make sure that your actions in this case are not going to embarrass you with your theory of inconsistency. And you get into the interesting area whether you can get into the examination for discovery on that theory. What if they say they're the best bank or the fastest company? Maybe you should explore that in discovery. Maybe you should drive them on a paper chase. How do you know you're the fastest courier? Have you done experiments to show you're the fastest courier? Have you done analysis? And if they can't show they're the fastest courier, maybe the fact that they lost your package or didn't get it there for 3 days later maybe showed that there was not only a breach of the contract, but you get to a secondary issue that Mel pointed out for punitive damages. Not only did they breach your contract of being a courier, but there was a collateral thing that you went to them because you thought they were the fastest courier, because they advertised that. So it may give you a rise by their advertising to a collateral warranty or a secondary cause of action that may give you rise for punitive damages, because not only did they breach your contract, but they breach your expectation. This reminds me of one final example that I can't resist. I have a case now against an insurance company, and their theme is "we care." So what do? They turn down my client's claim. So I now, as part of the case, and it's an ongoing case, emphasize in all my letters, I write to the insurance company, I put at the top, "So-and-so insurance company, we care." Just to remind them that I'm going to raise this at the trial, that if they're going to defend the case all the way through, I want to show how much they really care. I think, what's the TTC's? Doing it your way? I have to get back and beat me in 2 cases. So you may want to look even at the theme of the TTC. Was it going your way or my way, or the better way? Thank you. The better way is for the TTC to pay you and not defend the lawsuit. Now, as part of your theory, there's 2 aspects of your theory. Is you have to have your theory, whatever it is, and part of your theory is, the key parts of your theory is go to your strength of your theory. So if you have a promissory note case, as I mentioned earlier, keep emphasizing the promissory note. That's the strength of your case. Or if you have a personal injury case and you've got a broken bone or a scar, then keep showing the x-rays, keep showing the scar. Again, you may have some soft tissue injuries that don't show up in x-rays. There's some credibility issue about, but there's no doubt about the scar or about the broken bone. So you want to keep showing and emphasizing to the court the broken bones, the scar, and then of course indirectly you're going to raise the soft tissue injuries, but you want to have the foundation of your case, the things that there's no doubt about. You've got the scar across your forehead, and the lady will never be the same with the scar. You got the broken bone in the hand, and the person's never going to be a hockey player anymore. Then you raise the other issues, the soft tissue issues, the headaches, the neck pain, the low back pain. But you emphasize the strength of your case, the clear issues first, to show that you have a case, and then build on them. So I would suggest that as part of the theory, you hammer home the strength of your case and keep reminding the other side that the scar is not going to go away, the broken hand is not going to get better. Similarly, if you have a photograph that happens to show, for example, unfortunately, the Bernardo case. The Crown had the tapes. No matter what anybody said in this horrendous case, the tapes were not going to go away, and that was a case of unfortunate strength of keeping to show those videos because they were not going to go away. Similarly, on the other side is you want to, of course, stay away from your weaknesses, but you want to pick out the Achilles heel or the soft spot or the weakness in the other side. Every side, no matter how strong, has a weakness. If it's a bank, they don't want to look for the hundreds of thousands of documents that they got, and you say, well, I want to see all your documents on this topic, and they drive them crazy with or they don't want to do all kinds of calculations that they don't have to. So if you know, for example, that your case is a horror show as far as calculations, you may want to say to the bank, well, my client may owe the money, but I want to see your calculations for the last 22 years of those accounts to make sure you got the right balance. So that may be a weakness. The bank may be able to show that you owe money, but to show what they owe for the last 22 years, because you want to go back to a zero balance or something like that. So again, the other side has a weakness. No matter how strong they are, they may have a weakness. They may not want to come to court because they're too busy. They may not be able to speak English well and they're embarrassed. They may be in a bit of a labor strike. I always look for the other side's weakness and drive it home. And I drive it home again and again. And every time you have a conversation or every time you have a correspondence, you may even have to underline it if you're writing to Mr. DeJoni, but underline that weakness and drive that weakness home. For example, a very common weakness is Revenue Canada. Many people, unfortunately, don't do what they're supposed to do in Revenue Canada. They don't declare income tax fully. They make improper deductions. And that's a very, very common one in personal injury cases. People claim in an accident, oh, I can't work for the whole year. I want a year's lost wages, but they didn't file any income tax returns, or they had a ridiculous amount of income. They don't want to go to court on that. So if you're the defense counsel, you hammer home, let me see your tax returns. And you remind them that you're going to show to the judge that you had very little on your tax returns, or that if the businessman had incredible expenses, and at the time he was in an accident, he was using his air miles from his business to go on a personal trip, or he was charging the rented car on a personal trip, or something like that. Look for an embarrassment to the other side, even if it's a small embarrassment. You may think it's a small embarrassment, but to that person, they may not want to go to court. They may be scared of Revenue Canada. They may be scared their employer, they found out they were charging a certain meal to the business when they weren't supposed to. Everybody has a weakness. The person may have a very virtuous case and righteous case, but he may have a criminal record of the past in an unrelated matter that may come out in this case. And they may not want his criminal record to come out, or his adulterous relationship to come out. Even though it's only a collateral matter, it may come out in this lawsuit. He may not want it to come out. So you may take what looks like a good case and make it a weaker case if you're the defense by showing that you're going to hammer away at that adulterous relationship or that criminal record. Talking about a theory of the case reminds me of another situation I had where I was defending a lawsuit, and it was an insurance company, but the driver of our car just happened to be let out of jail, was going home from jail, got in an accident. And so the other plaintiff put in their pleading, as part of their theory to try and color the case, the defendant, while leaving the jail on his way home, got in a car accident. And again, they were trying to build up a theory to show that my client was unscrupulous, not the most credible person, by driving home the fact that he was coming from jail. It wasn't irrelevant, but they were trying to prevent a theory. So sometimes, although a certain theory may not be your main theme, it may be for collateral purposes you want to drive it home. For example, the adulterous affair on the other side may not be directly related to the case, but if you can show it even indirectly related to the case, and it's going to come up, and you're going to keep raising that adulterous relationship, they may not want to go ahead with the contract case or the personal injury case if the adulterous affair is going to be made a public matter in court. For way of example only, there's just a recent reported case, an unfortunate case. It's reported at page 3-13 of my notes. Somebody went in for a penis enlargement operation, and the doctor butchered the operation, to be frank, and it was an unfortunate operation. And the plaintiff, who was the victim there, sued the doctor. We didn't want to have his name in public. Obviously, he was embarrassed because the operation went bad, or he even wanted the operation. And so he brought a motion to have the case used with a pseudonym. He did not want to have his name used. That was just recently in the report. And so as soon as the other side sees that he doesn't want to have his name used, you can understand his theory. He wants confidentiality. The other side's theory has to be, well, he doesn't want his name used. We're going to do everything possible to get his name in or to embarrass him. So again, there's conflicting theories. If it's a subplot or a subtext, it's not the main part of the case, but if somebody doesn't want something to come out, then the other side has to do their best to make it come out. I just find it ironic, also as another sub-comment, the case of the butchered operation, the doctor in the butchered operation, his name was Stubbs, ironically. And if you really, I'm not going to say it here because it's a public thing, if you really want to see something interesting, look up that case, and you'll see the name of the judge is absolutely fascinating and relates to that case. 1999, 44 OR, 3D, 390. Look up the case, and the name of the judge is perfect for that case. If you see me afterwards, I might give you a clue. Then comes to the point about the atmosphere of a case. Each case has an atmosphere or a flavor, and there's very many factors involved. A lot depends on your character, the character of the other lawyer, the character of the clients, and even the character of the judge if it gets that far. And it all comes out what I call the chemistry of a case. And sometimes cases are gentlemanly and very friendly. Sometimes they're wars. You can't even trust the other side. You have to confirm everything by writing, and you always think you're going to be double-crossed. Or other ones are gentleman lawsuits. And so you have to decide from the start, as part of the theory of your case, you want to be a gentleman, you want to be a bulldog, you want to be an animal, or how do you want to present the case? And of course, you always want to be professional, and you want to be proper, but there's different aspects of proper and professional. You can be a professional bulldog, or you can be a professional gentleman. So as part of the theory of your case, and based on what your client wants, you have to decide how you're going to present the case, how aggressive you're going to be, how demanding you're going to be. Are you going to demand the defense on the 20th day? Are you going to demand the undertakings from the discovery 3 days after discovery? How aggressive and demanding are you going to be? Are you just going to play along in the normal course? So all these go into the theory of your case as underlining aspects. You want to come across as righteous and pure, or you want to come across as very aggressive. Now, a lot will depend, of course, on the nature of your client. You have to be consistent with the nature of your client and the chemistry of your client. If your client is a bulldog and wants to be a bulldog and very aggressive, then you may have to take away the timid attitude. If your client is a very gentleman, scholarly like the thing, they may want to present your case in that attitude. You have to sort of present your case in the scope and theory of the nature of your client, in your client's image. Are you taking the high moral ground, or are you taking the mercenary ground? Is money everything important, or are you talking about principle? And talking about the aspect of principle, I've had many cases, and I think you all have, where the clients always say, this is not really the money, it's a question of principle. And I think that in those situations, part of the theory of the case, you have an obligation to your client to say, principle is very important, give me a $10,000 retainer. Because that tests your client's principle right there, because it's for your own client, not so much for your self-protection, but if your client means that principle is important, you have to tell him to put his money where his mouth is to show that the principle is important. Now, once they say that principle is important, it gives you an important aspect, because maybe there are creative ways, as part of your theory, to settle the case without money. If it's only principle he wants, then maybe you can forget about claiming money. Maybe you can get a letter of apology. Maybe you can get free theater tickets if you're suing a theater. Maybe you can get free baseball tickets if you're suing a baseball stadium or something. Once it's principle involved, there's different ways. I think last year there was a case where the person was hassled at the baseball game and he got $210,000 against the Blue Jays. He was mainly suing about principle. They didn't settle with him, and eventually he got a large damages. So it's a question of principle going out of control. But if it is principle, I've had situations where if you have the right lawyer on the other side and the right people, you can negotiate as part of your theory to get the principle. For example, once they say it's principle, I say, okay, then maybe if somebody doesn't want to pay money because the other side's arguing principle, we can give money to charity. And everybody says, gee, that's a good idea. We'll give money to charity, and instead of giving $10,000 to the other side, we'll give their money to charity. That always sounds good, because who wants to say, neither side wants to say, oh, we don't want to give money to charity. You want to look good. So they always say, okay, well, I'll agree to give money to charity. Then we get into arguments, which charity and who gets the tax receipt. So it always gets sidelined. But it's a good thing to keep in mind that if there's a part of the theory of your case is principle, and not money, there are creative ways to solve that. Apologies, advertisement in the newspaper saying we regret that we did this, this, and this, et cetera, et cetera. So as part of the theory of your case, you want to look to see if there's creative ways to solve a problem without money, particularly if the other side doesn't have money or they're reluctant to give up money. Part of your job as counsel and part of the theory of your case is to look for ways to solve a case where there's no, particularly where there's no money available or it's not readily going to be available. Because you have to decide whether it's worth the cost of going to court, A, if you're not going to collect. And while we're on that topic, perhaps I have, can you put, I think the second slide or the next slide up? Yeah. This is a very classic cartoon, and I have a whole drawer full of these. It's the classic cartoon of two people fighting over a cow. One's pulling at one end, and one's pulling at the other end, and the lawyer's sitting in the underneath milking it. I don't mean that in a sarcastic point, but I find this very, very useful in explaining to a client the theory of the case often interferes with his pocketbook, and that he has to decide what's more important, his pocketbook or the principle of the theory of his case. And often, when I show this to a client, we're a very small apart amount in settlement. I say, if you want to go to trial or want to fight to the last degree on this case, the only people who are going to win are the winners. And I use this as a last straw, as a last resort to try and push through a settlement with my client. Because before you can settle with the other side, you have to get your client in the right settlement mood. So part of the theory of my case is, before you can even start settlement negotiation with the other side, or we start discussing settlement, you have to get your client ready for settlement. Because if you can do all the brilliant negotiating in the world and the other side can be ready to settle. If your client isn't in the mood for settlement, then you can't settle. So I first start settlement negotiations with my client to get it to be realistic and proper. And most of the time I don't use this, but this is my last arsenal. I take out this. I say, do you want me to milk you? Not in a negative way, but I have to get paid. If we're going to court, I'm going to be the winner. I'm going to be milking this cow, and you're going to be paying. So something like that may help you on the theory of your case or theory of settlement. Once you've got past this, you've got your client ready for settlement, then you get to the question of getting the other side ready for settlement. And I think one of the parts of the theory of your case is you have to decide if, let's say, the most common thing is you're looking for money. Let's just say you're looking for $25,000 by way of an example. But you can't just say, I'm looking for $25,000, period. There's literally hundreds of ways of getting that $25,000. And if you're really sincere in settlement, you have to look at whether the theory of your case fits in with getting that $25,000. For example, can you get the $25,000 at $1 a day for as many days as it takes to get the $25,000? Anytime I negotiate, because I do a lot of debt collection, the other guy says, we just can't afford to pay, we can't give you anything. I said, give me $1 a day. Your ears perk up. I say, well, give me $1 a day. Okay, well, maybe we can give you $1 a day. Then I go, $2 a day. Then it's $3 a day. But at least if you can start off by paying the $1 a day, it gets them in the payment mode. So if the other side is, if it's a money problem, and your client, let's say the financial institution or bank, they don't really care ultimately how long it takes to get the $25,000, then maybe one alternative is to get $1 a day, $5 a week. There's payment terms they can be. Or maybe you can take longer to pay if you get a guarantor. Or maybe they don't have to pay the $25,000 right away. Maybe they can not only pay in installments, but maybe they can give you security of a mortgage. Or maybe they can give you security of other guarantors. So once you've agreed on the $25,000, there's a multitude of ways that you can enforce that settlement to meet everybody's needs. Maybe they're willing to pay the $25,000, but they need time. But they don't want an execution, so you can agree withhold an execution. Get a consented judgment, but don't take it out. Get a consented judgment and get a judgment, but don't enforce the execution, or don't file the execution. So again, once you agree on the $25,000, there are thousands of alternatives that you can be creative to get that $25,000. So you shouldn't just say, I want the $25,000 tomorrow, and that's it. Because it may be to suit everybody's need that you can get the $25,000 over a period of time subject to certain conditions. Or sometimes, for example, you can forgive part of the debt. If you're suing for $25,000 and you can say, I'll take $12,500, or I'll take some of the material, I'll take some of the stuff we sold you back, you return some of the goods, we sold you $25,000 worth of merchandise, we'll take $12,000 back, give me $13,000. So again, these are just 1,000 examples that are at pages 27, 28, and 29 of how, when you agree on principle of settlement, you can implement a settlement. And again, it's part of a settlement. If the other side just says they just can't pay, then maybe if you explain to your client the legitimate tragedy on the other side, for example, they've had a cancer, they've had a heart attack, they've lost their job, and your client who's seeking the money sees that the other side is really under tragic circumstances, and the other side is not just trying to get out of a legitimate debt, but they're tragic circumstances, you can work that into the settlement that maybe your client won't take the whole amount. So all part of the settlement negotiation is part of the theory of your case. What are you really after? Does your client, the bank, or the insurance company really need the last $25,000, or are they just trying to send a message that they don't forgive debts easily? If it's a tragic case, maybe it's consistent with the theory of your case that the bank can get $20,000, or the insurance company can get $20,000, or maybe the insurance company will pay an extra $5,000 if they realize it's a really tragic case. If you could show as a theory of your case that your case really is tragic, and that this mother who's left a widow with several children needs that extra $5,000 because that's going to mean a difference to her and not to the insurance company. So all part of the theory of your case is presenting the tragedy of the special circumstance. Now, finally, I thought maybe I would just put up a couple more examples of theory of case that maybe we could shout out or talk about. Yeah. Here's a, can you perhaps make it a little center it? I just put these out for discussion purposes. Here's somebody, a lawyer, and he's dancing with perhaps a witness or a client in the courtroom, and perhaps that part of the theory of this case could be he's leading the witness. But again, I'm just putting that up for amusement, but an example of tactics of how you want to present your case. Is it your advantage to lead a witness? Your advantage not to lead a witness? If your witness is very simple and not a good witness, you may have to lead the witness. If your witness is astute and sharp and businesslike, they can just tell the story on their own. But if you have to lead the witness, do you want to get the wrath of the judge? Do you want to get the wrath of the other side? Is it worth the chance of leading your witness? So again, if your theory of your case is you got a bad client or a bad witness, but you have to go ahead, how are you going to get that evidence? Are you going to try and lead the witness? Next time you're leading a witness, remind this cartoon. The caption here is, and if I end my summation on a personal matter, Your Honor, I'd like to say that blue is definitely your color. So again, not the serious theory of your case, but your relationship with your judge may be very important. You may, want to say to the judge, very nice suit you have today, Your Honor. I like your haircut, Your Honor. It's important as part of the relationship of your theory of your case to have a good relationship with the court in most cases. So that if you're trying to present your case as a high moral case or a proper case, then it's important that if you're representing a client with integrity and decency, to want to show that your relationship with the court is also decent and that you're not being obnoxious to the court or belligerent to the court or contemptuous to the court. So the relationship of your theory of the case goes right through from your pleading, from your opening statement, right through the relationship of your judge, whether it's even complimenting him on his fine blue suit or his haircut or the judge's beautiful dress that day. And this caption here, see what happens when you find them not guilty. They summon his notes to the judge. That's similar to the previous cartoon that we started off with, thumb your nose at the jury. Again, you always want your theory to be logical, consistent, something that's acceptable in the balance of probability, something that a jury or a judge can accept as being subject to common sense and subject to acceptability. If a client comes in with a cockeyed story that you don't believe, that the average person is not going to believe, it's unlikely that a judge is going to believe it, and that's not even before it's cross-examined. So you want, as part of your theory, to be logical, consistent with the documents, consistent with the facts, consistent with the law, and presentable. Remember this, you don't want your case to be thumb in the nose at the judge or the jury, because it has a bad odor. It's not going to come across well. You want your case to be logical. Remember, don't thumb your nose at the judge or the jury. Next one, please. We're almost there. And this is, I'm afraid you've discredited yourself in the eyes of the jury. It's a person, somebody shooting the judge, and it shows a smoking gun. And again, that goes back to my theory that I emphasized before. If you have a key document or a key piece of evidence, hammer it home. That's the theory of your case. If you have a smoking gun in your case, here there's a smoking gun literally. But if in your case you have a promissory note, or you have a photograph, or you have a video, or you have something that's undisputed, some piece of evidence that's undisputed, eyewitnesses, whatever it is, hammer it home, hammer it home, hammer it home. The other side can't get away from that. So if you have a smoking gun in your case, make that the central point of your theory and shoot the gun. That's the law for you. You never know what the outcome of the trial is going to be. If it's head to the weight of the tail to the guilt. Again, the judge has got a coin, and here in this case, the judge is sarcastically flipping a coin to decide the outcome. What you want to do is give the judge a two-sided coin in your favor, both of them heads, so they come up heads in your favor, by presenting a theory of your case that always comes up heads in your favor, a theory that's logical and consistent, as I said before, a theory that when you sit down in the judge's chamber and thinks about it, when he's reserving his decision or he's preparing his decision, he'll think, gee, what's the logical, probable thing that happened here? And if you have a theory that's logical and probable and makes sense, the judge will likely accept it. And one of the best feelings in the world is when the judge gives his reasons. And besides saying that was an excellent presentation, counsel, what you want him to say first, the second thing you want him to say is the reasoning of his decision comes out in the same reason of your argument. Or you have to give written argument and he adopts your written argument. Or if you give oral argument and he adopts your oral argument and his reasons, he adopts your theory, then you've known you've done a job well done. So I wish you well in your theories, and I hope you don't use some of these tactics against me if I'm ever against you. Well, you're getting to a broad, are you talking about before the trial?
During the proceedings, from the time the proceedings are filed, up to
Well, that's a very good, because I had a client who actually I got rid of because they were trying, I was suing an insurance company, and they were trying to malign the insurance company through the internet. Maybe it's the same case, but I mean, I felt very uncomfortable because it was clever, and I got to give them credit. They started a website, and they asked for all people with a problem against this insurance company to write into the website, and they were having, and it's a tremendous strategy in a way, but it's our tradition in Canada, unlike the United States, that we try things in the court, not in the press, not in the website. So that's a good question, and excellent. To what extent a court will govern it? I guess whether it borders the line of contempt or abuse of the.
motion for the court to step in the motion or theory of the case.
Well, that would come under. So, wait. The question is whether you want to bring an interlocutory motion before trial. One way to do it is this to say, because you may not be able to stop it, freedom of speech, freedom of press, etc., is at the. If you're at the end, you're successful, then say, Your Honor, I want to speak to damages, I want to speak to costs. My clients put up with all this abuse on the internet, in the newspaper, in the magazines, on the phone shows. I want that to go to maybe punitive damages. And that could be, like Mel said, a collateral issue, a secondary, besides the issue in the lawsuit, there was a secondary problem or secondary cause of action. That may give rise to punitive damages. That may give rise to solicitor and client costs. You get into this delicate topic, of freedom of speech. Court have jurisdiction.
Jurisdiction, and maybe the government set up a board who might help.
Well, there's two questions. Again, the more question you ask, it's an excellent question. Is it the lawyer who's putting it out there, or is it the client? If the client putting it out there, it's a little nebulous. If the lawyer is putting it out there, I think in Canada, I'd like to hear what people say. In Canada, there's a tradition, at least, part of our English tradition, that we don't go out in between every recess of the court, give a speech to the press, and the speech, we try and I believe in that, unlike the American system where they try the cases in the streets and in the newspaper, we try and try them in the courts. I think that if a lawyer was abusing it, you could, as an officer of the court, bring a motion. I've never heard of that. I'm just guessing. If a lawyer was doing it, you could try and seek relief. I don't know the answer. If the client was doing it, it'd be a little bit. Well, the question is how much over the line they're going. See, if they're just expressing an opinion, now they may also be setting themselves up. She collected all the information. It may be great material and great fodder for cross-examination. At trial you might say, don't you believe in the court system? Don't you believe in our judge? Why are you doing this on the internet? Why are you doing it in the media? Why are you suing? You want to resolve this in the media? You want to resolve this in jail? So it may be great ammunition or tactic for trial. Now, maybe since they have a theory of exposing you in the media, maybe your theory of the case was to tell the court you've done everything proper and ethical and decent, and you want to present that theory right through. Good question. I don't know the answer, which is part of the beauty of our business. There's always new theories.
Thank you very much, Bernie. That was, again, most enlightening. Our next speaker is Katherine van Rensburg of the Smith Lyons firm. Katherine has had tremendous experience in interlocutory proceedings over the years, some of which I believe has been with myself. And I think I can fairly say ultimately she always succeeded. So I'd like to ask her to speak now. Thank you.
I enjoyed Bernie's story about the branch in the courtroom. I had occasion to be in the courtroom once in a CCAA proceeding where the parties were coming back time after time after time, and Justice Farley was presiding. And one weekend I dislocated my shoulder on the weekend and I had my arm in a sling. And Justice Farley walked into the courtroom and looked at all the counsel gathered there, and he said, "I see there's been some arm twisting since the last time we were in court." I'm very happy to be participating in this conference. I think I've learned a lot from the presentation so far this morning. My topic is advancing the theory of the case through interlocutory motions. In the course of researching my paper, I actually learned something that has helped to set my mind at ease after 16 years of practice. You'll see in my paper that I tried not to, but I fell into using a lot of war and battle and fight analogies. And I think it's difficult in our adversarial system to avoid using those kinds of analogies, to look for better analogies. And I talk about the motions being the battles of the litigation and war, and you don't necessarily lose. If you win all the battles, you won't necessarily win the war, and so on. I even got a little carried away and I started quoting Sun Tzu on the art of wars. Well, the problem is that there aren't a lot of other good analogies. When I was a young lawyer, in my first year of practice, I remember sitting in motions court over at 361 University, one of those small motions rooms like motion room B or C or D. And there was a list of about 60 matters on before the county court judge, and there were about 50 counsel and individuals standing and sitting in the courtroom. And I remember sitting there and watching this interchange, and it was a very acrimonious interchange between another young counsel and the judge. And I was quite horrified by what I saw, and it must have been apparent on my face. And the judge looked out over the room, all the counsel gathered there, and I could swear he looked right at me, and he said, "Despite what some people in this room might think, the practice of law is not a tea party, it's a fight." And I took that to heart. I thought that comment was directed right at me, that I somehow thought that the practice of law was a tea party, and from then on I decided that I would internalize that, and I would always remember that the practice of law is actually a fight, it's a battle, it's a war. And in any way, when I was preparing my paper, I was very happy to discover that that particular phrase was not designed specifically by that judge just for me. I actually discovered that there is legal authority for that proposition. In a 1915 case called Dale versus Toronto Railway, which is reported, by the way, at 34 Ontario Law Reports 104, Mr. Justice Riddell observed, and in that case he was considering an appeal, and the argument that was made in the appeal was that counsel had overstepped his role as being an impartial party representing his client's case. He'd made a very emotional plea to the jury, and that was one of the grounds of the appeal. And Justice Riddell observed, a jury trial is a fight and not an afternoon tea. So there is good legal authority for that proposition. We as litigators, I think all too often get caught up in the daily minor battles of the case, or cases that we handle. We fail to step back and look at the big picture. What's the case really about? What's the best way to achieve our client's objectives? And that's what I'd like to talk about in my presentation. Motions practice is an area where this can happen a lot. We lose sight of our theory. We concentrate on winning the dispute at hand. Whether it's a narrow procedural point, whether it's some offensive or objectionable conduct on the part of your opponent, we concentrate on winning that small battle when we really should be thinking about how the motion will assist in our overall strategy of the case, in getting us from A to B, and how it's going to help us to develop and test and advance our theory of the case. How many of us here today have sat in motions court and asked ourselves, why am I here? You're sitting there all day long and you're waiting to be heard, and suddenly you may realize this seems to be a pretty ridiculous point. If you told your friends that you were sitting in court and going to argue about this point, they'd say, what, are you crazy? Perhaps it wasn't our choice. Perhaps we were sent out by our principal. Perhaps we're a student or a young associate, and we were told, just go out and argue that motion for particulars or on refusals. Perhaps we were in fact told, as James Morton and his colleague Michael Iacovelli state, James has just left the room, so he won't hear this, but perhaps we were told, quote, cunning counsel use motions to gain a tactical advantage, to cause delay, or to drive up costs. The premise of my presentation is that that's not a good enough reason to bring a motion or to decide to oppose a motion. Tactics are one thing, the battle at hand is another thing, but your overall theory and strategy in your case should be kept in mind all the way through. You have to look at the relief you're seeking, the overall objectives of the case, the long-term goal, which is always, no matter what kind of a case you have, a satisfactory resolution for your client. In other words, how would or could the motion help to advance your theory of the case? Now, other presenters have offered their definition of a theory of the case, and I noticed in some of the papers there are definitions that are set out. I've set out a definition of my own, and I've also borrowed definitions from other sources. And the definition I like the most is offered by Professor McElhaney in his trial notebook, which reads as follows. The theory of the case is the basic underlying idea that explains not only the legal theory and factual background, but also ties as much of the evidence as possible into a coherent and credible whole. Whether it's simple and unadorned, or subtle and sophisticated, the theory of the case is a product of the advocate. It is the basic concept around which everything else revolves. It is what the advocate creates out of the legal theories and the facts. I like that, a product of the advocate, what the advocate creates out of the legal theories and the facts. You, as the advocate, have the ability, the responsibility, to make your case the best it can be. McElhaney says that a theory of a case should be plausible, it should be simple, even if ultimately your facts are complex, and it should be something that you as counsel can put forward with sincerity that you believe in. As Bernie said in his presentation, everything you do in the course of an action should plug into the theory of the case. McElhaney says, and I think it's a counsel of perfection, never do anything in your case which is inconsistent with your theory of the case. So how can motions, interlocutory motions, help to achieve that objective of putting forward your theory of the case? I classify motions into 4 basic types. The first are dispositive motions. That is motions that are capable of bringing the action to a swift conclusion. Examples of dispositive motions are summary judgment motions, motions to strike a claim or a defense for failure to disclose a cause of action or a defense. An interlocutory injunction motion can also be dispositive. A second category of motions are motions that are preservative. These are the ones that can help to preserve the status quo between the parties, preserve ultimately the fruits of the litigation, so there's something left to fight about. Now, in a sense, interlocutory injunctions are preservative motions, but in practical experience, they often tend to be dispositive. Motions can also be useful in the discovery process. I give them a category all their own, discovery motions. Motions for a further and better affidavit of documents, for answers to questions refused on discovery, motions for production of documents or examination of a third-party witness. And finally, there are what I'd call procedural motions. Those are motions that seek compliance with the rules of pleading, with time limits under the rules. They deal with, for example, the time and place of discovery, set time limits for taking certain steps in the litigation process. Procedural motions can be truly necessary. For example, a motion for leave to commence an action against a bankrupt company has to be brought. A motion to extend a limitation period, if a limitation period has expired, has to be brought. And procedural motions can also be made necessary by the conduct of opposing counsel. You may have to bring a motion to get the action back on track again. In my paper, I've set out a number of considerations, things to think about in deciding whether to bring or oppose a motion that go, I hope, beyond purely tactical considerations. And the first is the whole question of momentum. No matter what type of motion you're contemplating, it will affect the momentum of your case. Every case has its own momentum. As a general rule, plaintiffs want an action to proceed quickly. They're optimistic at the beginning of the action, and the longer the action is delayed, the less optimistic they may become. They may feel that justice delayed is justice denied. Plaintiffs, it's usually in their interest to move the action along. And also, as a general rule, defense counsel believe that delay can help their clients for the opposite reason. Unless, of course, they're considering some type of a preemptive strike at the plaintiff's action. A plaintiff can become distracted, lose interest in the action, the memories fade, the plaintiff can be frustrated by the delay and perhaps accept a lesser amount in settlement. So a motion can either speed up the litigation or it can slow it down. Speeding up the litigation, motions can be useful in expediting the process, especially where the motion is for dispositive relief. If they're successful, they'll help your client to literally get to court more quickly and get an enforceable judgment more quickly. Even when they're unsuccessful, they do have the effect of forcing the other side to come forward by providing affidavit evidence, participating in cross-examinations, can give you an early look at your opponent's case. Early motions can help to prompt settlement discussions. They can literally bring the other side to the table. On the other hand, and as we all know, motions can serve to slow down the process. You can get bogged down on interlocutory issues. You can lose sight of the main issues in dispute. If you're busy bringing motions, of course, you can't set your action down for trial. Motions lead to orders, and orders can lead to appeals. As Bernie pointed out, if your case is urgent, then it's really inconsistent to be bringing a lot of motions. It suggests that, in fact, there isn't that degree of urgency if you're caught up in arguing about interlocutory matters. So before you bring a motion, consider that momentum factor and its impact on the momentum of your case. Is the motion necessary to keep the action moving? Is there a risk that you may succeed in a procedural motion only to have the other side appeal the decision and then result in further delay? How important is the relief that you're seeking in that particular motion when weighed against these momentum factors? We've all encountered the challenge of a motion that seemed like a really good idea at the time, and as it's taken on a life of its own, you've regretted having brought that particular motion or even opposed that particular relief that your opponent was seeking. How can you make motions work for you without losing momentum? One suggestion is to combine the types of relief that you're seeking. You're going to be in court anyway. You may have to wait all day to have your motion heard. So consider bringing other types of things or ask for other types of relief in your notice of motion. If you're bringing a motion for answers to refusals, at the same time, ask for a further and better affidavit of documents, speaking to documents that should be revealed if the questions that have been refused are ordered to be answered by the court. Ask the court to set timelines for compliance with the relief that you're seeking and sanctions for non-compliance. If your opponent brings a motion, let's say your opponent brings a motion with a return date that's far, far off into the future, and you think that your opponent is doing this for the purpose of delay, there's nothing to prevent you from serving a notice of return of motion to bring that motion on more quickly for a hearing. Or likewise, if your opponent brings a motion and there are other matters which can be argued, perhaps not entirely relevant to that particular motion, consider bringing a cross motion so that you can use the court's time productively and deal with issues that are of interest to your client and will benefit your case. A second consideration apart from momentum in deciding to bring a motion to advance your theory of the case is whether that motion could effectively cut to the chase and end the litigation, get you into court quickly, and get some type of dispositive relief. And these are the summary judgment motion, interlocutory injunctions, Rule 21 motions as well. If you're successful, your court will avoid potentially years of litigation and legal bills. Even when unsuccessful, the motions can flush out the issues. You may be able to use the cross-examinations as discovery transcripts if the other side agrees, and ultimately reduce the overall time. And these kinds of motions do put a lot of pressure on the parties for settlement, because after all, one of the parties is going to be fighting for its life. If the motion is decided in the other one's favor, then they can lose everything, so there will be greater pressure for settlement. I'd just like to say a few words about summary judgment motions. There's been a lot of discussion about the future of summary judgment after the Aguoni decision in the Court of Appeal and some other cases like Rexcraft that have followed that. In the Aguoni case, the Court of Appeal, in a decision by Mr. Justice Borens, reversed the decision of a motions judge on summary judgment, and the motions judge had effectively granted summary judgment in favor of the defendant, concluding that the plaintiff's action was barred by a limitation period. And Justice Borens overturned that decision, and he found that the judge hearing the summary judgment motion had really overstepped his role. Justice Borens stated, "In ruling on a motion for summary judgment, the court will never assess credibility, weigh the evidence, or find the facts. Evaluating credibility, weighing evidence, and drawing factual inferences are all functions reserved for the trier of fact." He then went on to emphasize the right of a party to have a trial and the fact that summary judgment motions were useful for striking through sham claims and defenses, but he seemed to limit the usefulness to those kinds of cases. Many commentators have expressed the view that these cases have really sounded the death knell for a summary judgment process in Ontario, except in the very clearest of cases. And if you combine that with Rule 20.06, which provides for solicitor-client costs, if you're unsuccessful in a summary judgment motion, unless you can show that the motion was reasonable, when you put it against that test of the Court of Appeal that the Court of Appeal has set, it may be that many motions judges will find that it wasn't reasonable to have brought a summary judgment motion. And a lot of counsel will be reluctant to bring these motions. in my view, I think there's still a very strong role for the summary judgment motion to play. I think it's still useful, and I think it should be exploited wherever possible by counsel. It is, after all, a very, very effective way to get a party's attention, to bring the matter to court for a quick disposition. If you bring a summary judgment motion when there's clearly a material fact in dispute and you know it, that's obviously very risky. But if you bring a motion when you feel your theory of the case, your facts are strong, and you want to force the other side to, as they say, put their best foot forward, to see what their case is all about, to test that, and to evaluate their theory and their evidence, I think it's a less risky proposition. It may be that you'll get that kind of disclosure, and you may decide that you want to abandon your motion, and you may have to pay some costs of doing that. But it's still a useful exercise in those kinds of cases. Another thing to keep in mind about summary judgment motions is you have a much greater chance of succeeding if you've got a solid theory of your case. The judge hearing a summary judgment motion has to determine whether there are material facts in dispute. And I think there's a lot of room for discretion in determining what is a material fact in that characterization that the judge has to make. If you have a strong, a logical, a well-articulated theory, you may be able to persuade the judge that although there are factual issues, they're unnecessary to your theory, they're unnecessary to allow your client to prevail, and that your position should prevail notwithstanding these collateral factual issues that are there. So I think there's still a lot of scope, a lot of room for discretion on the part of a judge to determine what is material, what's not material, and part of your challenge will be putting that forward with a good theory so that the court will find that where there are factual disputes, they aren't material to your case. Of course, if you're responding to a summary judgment motion, the opposite really holds true. It's not in your client's interest, unless you are cross-moving for summary judgment, to say that the issues are simple and clear. You'll want to establish all of the key facts that are in dispute, many of which you'll say are essential to your defense. And just a word here about tactics and strategy. The moving party in a summary judgment motion often will have the upper hand. They're timing the motion. They're bringing the motion often very early in the proceedings, before there's been discovery, before there's been an exchange of affidavits, of documents. Don't make the mistake of allowing the moving party to set the agenda. If you're responding to a summary judgment motion, it's a dispositive motion, your client could lose everything, then make sure that you are equipped with everything that you need to be able to support your theory of your defense or of your case. And that means if the other side hasn't delivered an affidavit of documents and you need to see those documents in order to put forward your defense, ask for an affidavit of documents. The rules don't disappear just because you're in the summary judgment forum. Get third-party discovery. Examine a witness on a pending motion if you need to. Try and marshal all of the facts that will establish that there is a tribal issue. Many of the same considerations apply to injunction motions. They certainly have the effect of focusing the party's attention. They bring the parties to court quickly, and when successful, they usually end the litigation. Often you're left with what is really an academic dispute. Although the test for granting an injunction does not require the plaintiff any longer, except in certain types of cases, to establish a strong prima facie case, as a practical matter, the merits are very, very important in interlocutory injunction proceedings, and the parties will rarely leave any relevant factual stone unturned when they exchange their affidavits and they conduct their cross-examinations before the hearing. So it's critical in an injunction motion to have, again, a very well-developed theory of your case, which is capable of persuading the court in a hearing which may last only a couple of hours, may last a day, if you're lucky, may last 2 days. You don't have the luxury of a trial to persuade the court. That's why it's so critical to put forward your theory in your affidavit materials, to put it before the court in a very firm and well-supported manner. Another good reason, apart from momentum, considerations of whether a motion could be dispositive, another good reason perhaps to bring a motion is that it can be preservative. It can help to advance your case by preserving the fruits of the litigation. If the case is about an interest in land, a motion for a certificate of pending litigation should be considered. Not only will that motion ensure that there is something left to fight about at the end of the day, but having that certificate on title can prove a very strong incentive for the defendant to come to the table at an early stage in the proceedings. Likewise, a motion for interim recovery or preservation of property can bring matters to a head. Frequently, the court will decide the plaintiff's claim at a very early stage, their entitlement to that disputed asset, so that the rest of the litigation could become academic. So if your theory of the case is that your client has been deprived of an interest in something that's tangible, find a way, through an interlocutory motion, to protect that interest, at the same time sending a message to the defendant that it hasn't gotten away with its conduct. You've tied up that interest so that there will be something to fight about. I'd like to turn to discovery motions and how they can be important and essential in advancing your theory of the case. In developing your theory, you will have considered what evidence or proof you need for each element of your case. This should be the focus of your effort in oral discovery, to get admissions, to identify witnesses and documents that are going to help to support your case. But another objective is to ensure that you fully understand your opponent's case, and so that when you're presenting your theory at trial, you're going to be able to account for things that may seem to initially support your opponent's case. You'll have an answer for those things. So one of the focuses of discovery is to try to flush out your opponent, to examine it, and to find ways to use things that may support their case and use it in your own benefit. And all of this should be kept in mind when you're deciding whether and when to bring a discovery motion. All too often, we move on refusals simply because there's a difference of opinion on whether something's relevant or not. There may be a suspicion that you're onto something if there's a refusal, and that may be worth exploiting. Arguing over a refusal on what is really a collateral point to your case doesn't make a lot of sense. It eats up time and it eats up money. On the other hand, if there's a line of questions that put some type of pressure on the other side, such as questions seeking medical information or personal financial information, I call these it's none of your business kinds of questions, because that's usually the answer that you get from counsel. It's none of your business. You can't ask that question. If these questions are in fact relevant, or if there's an aura of relevance, they may be worth pursuing through a motion, because you know that you've struck pay dirt by that refusal. You know it's something that the person doesn't want to have disclosed to you, and they can be very useful in putting pressure on the other side. It can be used to advantage in both developing your theory and in settlement discussions. I'd like to finish by just talking about two final things to think about when considering how a motion may impact your case. The first is, to state the obvious, motions cost money. They cost money to bring, and they can carry cost implications when they're lost. If your client has deep pockets, he or she may not care whether your strategy is to motion the other side to death. But these days, the courts care, and they actively discourage these kinds of strategies. You may be, in fact, if you bring these kinds of motions for the purpose of running up costs on the other side or for delay, you may be inviting the case to be case managed. Also, another point worth thinking about is that nuisance motions can send a very strong message to the other side and their client. It may suggest that if you keep bringing these motions, you really don't have a very good claim or defense on the merits. Think about that factor. It may suggest that you don't really have a very good theory of the case if you're busy and embroiled in these kinds of nuisance motions. Again, dispositive motions can eventually save your client money in the long run. The risks of bringing motions and spending your client's money and what kind of message you're sending to the other side in bringing motions have to be assessed. My last point, my second closing point, is that bringing motions can have unintended results, and you have to think about those. They can present opportunities for the other side that might not otherwise arise, particularly at an early stage in the litigation. any motion that needs to be supported by an affidavit opens the door to cross-examination. In our system, it's pretty much the rule that if you file an affidavit, there's an absolute right to cross-examine on that affidavit. The courts will recognize the right for an adjournment and an opportunity to cross-examine. So the cross-examination can allow your opponent to get into areas which are both in your affidavit and not necessarily within your affidavit. The cases are clear that they can cross-examine on anything that's relevant to the motion. Although they're not supposed to cross-examine on things that aren't relevant to the particular motion, often the range of cross-examination can take you into a lot of areas that perhaps you're not prepared to deal with at that particular time in the process. So if you're considering bringing a motion and it needs to be supported by an affidavit, think about the fact that you're giving your opponent the opportunity for early discovery, perhaps without your own corresponding right. They may not file an affidavit. You may not have a right to do your own cross-examination at that stage in the litigation. Motions can give what I call a sneak preview of the party's case, an opportunity to assess you as counsel and your witness, and may result in evidence on cross-examination that can come back, after all, it's sworn evidence that can come back to haunt you in the balance of the litigation. This isn't to discourage motions altogether, but think about the material you file on a motion, whether it's necessary to file an affidavit. Think about the timing of your motion in the action, whether you've developed your theory of the case, and whether this could be exploited in some way by the other side. Again, if you have a solid theory of your case, if you've communicated and your client understands that theory, you'll have a better method of dealing with a cross-examination at a very early stage in the litigation that could go beyond the scope of the particular relief that you're seeking in your motion. Another point with motions having unintended results, motions can take on a life of their own. They can provide an opportunity for delay. These can increase expense even where they're designed to reduce expense and cut to the chase. We've all seen motions for summary judgment then spawn motions within motions for production, for the time and place of cross-examination and so forth. They may have a negative impact on your ability to put forward your theory of the case, and I'd just like to deal briefly with the example of a pleadings motion. I think all too often we as counsel will look at a defective pleading that is filed by our opponent, and perhaps it's instinctive. We like to see a good pleading. We think we could plead their case better, and we like to take a shot at the pleading and move to strike it. What should we think about before we bring pleadings motions? First of all, most of the time, judges will not strike a bad pleading. They'll grant leave to amend. So if your opponent has a bad pleading, you don't necessarily want to do him the favor of going in and cleaning it up for him at an early stage. Even if your opponent's pleading is so bald that he can't articulate his theory to the motions court judge, the chances are the judge will find a theory for him, and to make matters worse, to add insult to injury, may even use your submissions as the basis for the amendments that are required to be made to the pleading. So you'll have a more focused opponent who's got a better pleading at the outset of the case, and all you'll get perhaps for your efforts is a psychological sense of victory and maybe a few dollars of costs for your client. On the other hand, pleadings motions can be very helpful if they to try to strike allegations that could be detrimental and prejudicial to your client. You have to look at the pleading. As Mel had suggested, the pleadings are very, very critical in determining the ambit of what's going to happen in the balance of the litigation. It determines the scope of your discovery. It determines the scope of permissible inquiries at trial. So if there's a lot of superfluous stuff that's included in the pleadings that you don't want to be pursued through the discovery process, if there's a way to bring the motion to have those paragraphs and those sentences struck from the pleading, then it's consistent with your theory of the case to bring that kind of a motion. On the other hand, you may want to keep outlandish, ridiculous, inflammatory kinds of allegations in your opponent's pleading, because that will allow you to fruitfully pursue those in the discovery process, and may also cast some doubt on the propriety of the theory of your opponent's case. By way of conclusion, motions present wonderful opportunities to develop and advance your theory of the case. In deciding whether or not to bring them, you should always keep your eye on the prize. How are you going to get from A to B? And whether what is sought in the motion is ultimately going to help you to get there. And getting back to my war analogies, if I can be forgiven, I'm going to quote Sun Tzu on The Art of War. He said, cleverness has never been seen associated with long delays. Let your great object be victory, not lengthy campaigns. And the moral of this is keep your eye on the theory of your case, use your motions wisely in your campaigns, not just to lengthen the campaigns, but to achieve a victory.
I'd like to thank Ms. van Rensburg for that, I shouldn't say illuminating, the lights didn't go on and off, but that very helpful discussion. We're just about to break for lunch, but Mr. Gasee had one more slide he wanted to show that answers the question, I think, raised by the participant. And I fear it's upside down, but I'll let Mr. Gasee speak to it.
Two thoughts on the person had a very good question here about to what extent will the court take part or do tactics. The question about out-of-court tactics and what happens in the media or the web is one thing. There was just a recent, in the Just Desserts case, there was just a recent tactic where one of the lawyers used on Mr. Potato Head. You probably read in the paper or heard about there was a major issue in the Just Desserts case of identifying who were the people who did the robbery and the shooting, and there was serious questions of identification. And one of the lawyers brought in a puppet, I think it's called Mr. Potato Head, where you can exchange the parts. And he showed that by changing the hat, or changing the nose, or by changing the ears, he actually did it for the jury. He took a puppet, he moved the ears around, and the hat around, and the mustache around. Now, by just changing different features, you get a different person. And so there was an example of a dramatic use or tactic of a puppet in court, or to present a theory that identification was a very, very key part of the case, and through a slight change of dress or cosmetics, you could change the identification. This, you may want to remember this diagram where here the lawyer is using puppets to demonstrate his case to the jury. I can't read this. I think the jury can do without the demonstration, Mr. Burns. So that judge ruled in your favor. You can't use that. That's all I'll say.
Thank you very much again, Mr. Gasee. We're now going to break for luncheon. We're going to resume again at 1:30, so if people could be back for that point. Thank you again.